must pay $780,000 to $52,000 to 52,000 truck student. Oh, Jesus. It seems as though trucking companies are finally getting a long overdue wake-up call. Roll it. Hey there, welcome to Trucking Topics Today, where we provide information for your trucking journey. My name is Tony, and I am your host here on the channel. By the way, if you love everything trucking, then you are in the right place right now. Please consider supporting the channel by subscribing and tap the notification bell so that you will be notified of all future video drops. We also have a podcast, Trucking Topics Today, that you can find on Spotify, Apple Podcasts, Anchor, and other podcast platforms. Look for us on your favorite podcast channel today. Also, if you like everything reselling, please take a look for our YouTube channel, Big Box Flippers. There are some fun videos there, and I will have the link below for you. So let's get after it. Within the past 4 years, drivers have won several court cases when it comes to non-driving time compensation. A federal court in California told Walmart in January that it owed its California truck drivers $54.6 million, and the opinion said that Walmart violated the law when it didn't pay truck drivers for rest breaks and other non-driving time, which is really interesting because I was under the impression that they did. In October 2018, a federal court in Arkansas decided in a class action suit against PAM Transport that drivers should be paid for every hour they spend in their trucks while not sleeping, about 16 hours a day, of at least minimum wage pay. In 2017, a Nebraska court said Warner Enterprises, accused of pay practice violations, must pay $780,000 to 52,000 student truck drivers. And in 2016, C.R. England paid $2.35 million in back wages to more than 6,000 drivers. Now, this video is about the most recent case with Missouri-based New Prime Incorporated, also known as Prime. It's the latest legal action to push the boundaries of a question recently making its way through America's courts, and that's whether truck drivers deserve minimum wage for non-driving duties. In a very low-key announcement, Prime has settled 2 class action lawsuits with its drivers. After years of court action, stretching all the way to the Supreme Court, 26,000 former and current drivers are entitled to their share of the $28 million settlement. Both sides claimed that drivers were not fairly compensated. With regard to Oliveira v. New Prime Incorporated, the ruling from the nation's highest court concerned Prime's ability to settle its dispute with Oliveira through arbitration. The court ruled in favor of Oliveira, which also had wide-ranging implications for how drivers are paid. The core issue in both cases stemmed from a decades-old practice in the trucking industry in which drivers are paid per mile, not hourly or annually. Oliveira argued that he deserved to be paid at least the minimum wage. As we all know, drivers spend weeks on the road for work and hours every day doing non-driving work tasks. In one 2016 survey, almost 63% of truck drivers said they waited at least 3 hours every time they were at a shipping dock, right? This waiting time typically goes unpaid. However, in my experience over the past few years, I have seen more companies starting to pay detention, and at a higher rate. Martin Transport, for example, pays detention automatically after a certain amount of time. And of course, there are other carriers out there starting to do the same. The U.S. Department of Labor says that any work which an employee is required to perform while traveling must be counted as hours worked. Now, experts are saying the case and its massive settlement could set a precedent for truck drivers who say their companies aren't paying fair wages, and may create a path for drivers who have documented evidence of unpaid work to fight for back pay in court. So the way I read this, I think that this most recent case tips the scale in the driver's favor. If a driver launches legal action against a trucking company, a precedent has now been set that could be referred to. This is the wake-up call that our industry needed. Our $800 billion trucking industry relies on owner-operators who own their own trucks and may be contracted with other companies. About 350,000 of the nation's 1.9 million truck drivers are owner-operators. And by the way, 90% of those owner-operators companies are 6 trucks or less. So like most trucking companies, Prime classifies its owner-operators as contractors and therefore not privy to certain worker protections. The Supreme Court ruled in its unanimous opinion last year that Prime's owner-operators were indeed employees. So what are your opinions of this most recent settlement and the court wins that came before this case for our trucking industry? Is it the wake-up call that is being claimed? Have you seen any benefit at your company since these rulings? Let us know in the comments below. Please subscribe, like, and share to support our channel. I hope that you got some value out of this video. Look for our next video dropping soon. And in the meantime, please be safe out there.